All right, chapter 8 now. So in chapter 8, we're going to look at issues that may affect either the validity or the performance of an agreement. We're going to check issues such as misrepresentation, and then duress, undue influence, mistakes, and others in a contract. So let's start with misrepresentation. What is misrepresentation? It is a false statement of fact. And that false statement persuades or leads someone to enter into a contract. So sometimes we are persuaded to buy something on Craigslist or Facebook Marketplace because of some characteristics, and after we get the product, we find out that it was a lie, it was a false statement. It could be the year of manufacturing, or could be that there's a steel guarantee available, or whatever the characteristic is. So whenever there's a false statement that leads someone into a contract, there's misrepresentation. And the victim may have remedies available. They may cancel the contract, or they may even sue for damages. So there are 3 types of misrepresentation. There's innocent, fraudulent, and negligent. So the main aspect here, the main thing I want to emphasize is that damages, they are available only for negligent and fraudulent. Damages are not available for innocent misrepresentation. If there's innocent misrepresentation, the remedy will be rescission. What is rescission? To cancel the contract. Rescission is cancellation of a contract. So in fraudulent and negligent, on the top of rescission, there's still damages available, but not for innocent. What is an innocent misrepresentation? Well, the person that makes the statement, they honestly believe it to be true. So let's say you want to buy my Porsche. And you ask me, hey, João, is the gear working well? And I say, yes, it is. I've been driving the car every day. I honestly believe it is. Then you buy the car, you take it to a mechanic, and the mechanic says, hey, the gear needs to be fixed. So you were a victim of a false statement, but the false statement was not intentional. I honestly believe it to be true. So what's your remedy available? It's there in the slide. Rescission. Rescission is the only remedy. Give me back the car, I'll give you back the money. And even rescission may not be available. Let's say, if it's impossible to restore. Let's say when you were driving out of the mechanic, you were involved in a car accident and the car was totaled, totally destroyed. So you cannot return the car to me. So no rescission available. Or let's say you found out about the innocent misrepresentation, but then you decided to just let it go. Okay, let it go. It was a good bargain, by the way. Okay. So in this second example, you learn about the innocent misrepresentation, but you confirm the contract. You say, okay, I don't care about it. And then the fraudulent misrepresentation is different. This, the person is making a false statement deliberately, knowingly. So I took my Porsche to the mechanic told me, hey, João, the gear needs to be fixed. And then instead of having it fixed, I decided to sell my Porsche. And then you ask me, hey, João, is the gear working well? I know it's not, but I tell you, yes, it's working well. then I am deliberately lying to you. Because it's fraudulent misrepresentation, rescission is available and also damages. If you suffer damages, you can also sue me for damages. So you may have your money back plus sue for damages. Now, another example, another situation would be negligent misrepresentation. Well, negligent misrepresentation is usually when we are an expert and we make a mistake. We make a mistake, an unintentional mistake, a careless mistake. So let's say now I am a mechanic, you're taking a car for me to verify, and I say, yes, the gear is working well, but actually I failed to review the gear or test the gear properly. But I did not lie to you intentionally. As a mechanic, I made a mistake. So I was negligent. So in this case, negligent misrepresentation. Rescission is available, but also damages. You can also sue for damages. Are these clear? So even though the contract is legal, when I sell my horse to you, you may have been the victim of misrepresentation. So the contract may be canceled or not, depending on what the victim wants to do. Any questions here? Are the examples okay? All right. Question for you then. A. Why are you so confident with A? Because it's innocent. Innocent damages are not available for innocent misrepresentation. So this is also memorization, straightforward. If you remember that damages are not available for innocent misrepresentation, you would go straight to A. Others, so fraudulent, negligent, false statement in the contract would be negligent, intentional, fraudulent. So yes, A is the right answer. All right, now let's look at duress. Duress includes a threat, a more serious threat, threat of physical violence, criminal prosecution. So I know you are a rich person, so I come to you and I say, hey, will you lend 10,000 to me? And you say no. And then I take my gun out and I say, hey, lend 10,000 to me now, or I'm gonna shoot. I'm threatening you with violence. Now that you're learning duress, you know that your best remedy is to lend me the 10,000. The next day, you hire a lawyer and you sue me. Because you only entered into that contract because you were a victim of duress. Right? This contract is voidable. What is a voidable contract?
I can argue about the contract. Come out of it if I provide relevant information about it.
Yes, as a victim, you may have a way out. But is the contract illegal, void? It's not. When it's voidable, it's not void, it's voidable. In other words, it's a legal contract, but the victim may challenge this contract in court because they were a victim of, in this case, duress. Okay, so you are very rich. I threaten you with a gun. You lend me 10,000. Because you're very rich, you think to yourself, hey, I won't bother. You may not bother. It's a legal contract. So when it's voidable, you may challenge it in court. or you may not. It's up to you. Now, undue influence. Undue influence is not as serious as duress. Undue influence is related to the abuse of trust. We talked about abuse of trust when we discussed the intention. And the rules here are the same. So if I sell something to my daughter, domestic relationship, there's a presumption of no intention, as we discussed some minutes ago. And there's also a presumption of undue influence. The law courts, they understand that I abused my daughter's trust. And we go through the same exercise. If we establish in court that the car was of a fair market value, my daughter needed a car, and she had opportunity to seek independent legal advice, we rebut this presumption. We set this presumption aside. Okay? So that's what undue influence is. When one party abuses on their dominant position and trust they enjoy. The contract is also voidable, not void, voidable. Now, unconscionable transaction. In unconscionable transaction, one party has been taken advantage of. So let's think about this example. You and your partner and your 4 children, you are traveling on the road, 2 a.m., and you have a flat tire. And then you find out you have no spare tire. Your partner is yelling at you, your children are crying, they are hungry, whining. So you are in a real bad situation. And I just passed by, stop by to help you. And I have a spare tire that fits your car. But because of your situation, I will take advantage of you. I will not lend my spare tire to you. I will sell it to you for $10,000. Would a normal person pay $10,000 for a spare tire? No. So this is an example of an unconscionable transaction. A transaction that no one would enter into, but because of their current situation. So because you know this now, you would buy the spare tire for $10,000, you would write me a check. Next day, you would sue me for unconscionable transaction. In those situations, the courts will not cancel the contract, but they would correct the transaction. A regular spare tire would, let's say, would cost $500. So the court would order me to return to you $9,500. You would still have to pay for the spare tire, but a reasonable fair price, not an unconscionable price, unreasonable price. Does it make sense? All right, question for you. All of them are true except one. Which one is false? Anyone? B?
False one. False one.
Yes. Which one is false? B? Why B? It's correct. B is false. Why?
Definitely start.
Oh, it's in court. So if the court presumes the existence, the person asking for the return of property will automatically get it back. In other words, the court would automatically order the property to go back to the person. Why is this false?
Because there's no.
This would be currently targeting mortgage but not fully released.
Not sure I understood what you meant. So say it's more reason,
Back to the car analogy, instead of the full return of $10,000, you have to get 500.
Okay,
You don't get the money all back, but the sum that is currently.
okay, but this point would be valid for unconscionable transaction. Here in this case, we're talking about undue influence. So there was abuse of trust or the dominant position. Anyone? Why is B false?
Because it's voidable.
Okay, it's voidable. The fact that it's voidable, it means that the victim may challenge this in court or not. But still not the reason. So what did I tell you here? There's a presumption. Can we set this presumption aside? Can we strike back this presumption? If we cannot set this presumption aside, it means that when there's a presumption, it's going to be always, it cannot be reverted. And this is not true. When there's a presumption, what is to presume? Can anyone look at the dictionary, please? To presume? What is to presume?
Suppose that something is the case on the basis of probability.
Suppose that something is the case on the basis of probability. So the courts, they suppose that undue influence is there when there's a special relationship. The courts suppose.
Oh, they can't come to
It's
the-
not that the courts are sure. They suppose. The fact that they suppose, it may be the case that the other party may prove in contrary. Remember my example to you. I sold my car to my daughter. Courts will suppose there was undue influence because it's a domestic relationship. But what if I tell the courts that it was a fair market value, my daughter needed the car, she had an opportunity to seek independent legal advice? Is this supposing confirmed or not? No, it's not confirmed. So this one is false because when there's a presumption of undue influence, the other party will not automatically get it back. Because it may be the case that the party, the defendant, they may prove contrary to this presumption. For those who are paying attention, does it make sense? when there's a presumption, presumption is not certainty. Certainty is one thing, presumption is another thing. Presumption is close to certainty, but it's not certainty. Right? So that's why this one is wrong. All other statements, they are true. Except this one. All right, now let's look at mistake. So mistake is related to consensus. And we'll see some examples there. When I talk about mistake, I'm not talking about a real, regular life mistake. No, I'm talking about legal mistake, mistake in law. When we are negligent, in other words, when we are careful reading an agreement, we cannot claim it was a mistake. If we are negligent, it's not a mistake in law. We are just negligent and we have to suffer the consequences of being negligent. Courts, they will usually offer remedies when there's a mistake of fact other than the law. A mistake of fact would be raining, sunny. I thought it was raining, I thought it was sunny. So those are facts. A mistake of law would be, oh, I killed someone, but I didn't know this was a murder. This would be a mistake of law. You commit a criminal offense, and in your defense, you say, no, I didn't know this was a criminal offense. No, this is not a valid defense. Okay, so courts, they are worried about a fact. In some specific situations, such as when there's an obvious error, the courts, they will rectify, they will correct the agreement. So let's say I sold 10,000 liters of milk. And when we drafted the agreement, 10 was missing, so it was only 1,000 liter. But both parties agree it should be 10,000, not 1,000. So courts, they may correct the agreement. Okay, when it's an obvious mistake. As long as parties agree. If parties disagree, then there's a misunderstanding. We'll see in a minute. Shared mistake. I gave you an example already, but I'll repeat. A shared mistake is when both parties to the agreement, they make the same fundamental mistake. So the example is, I sold my Porsche to you. My Porsche was parked in the parking lot. Unknown to both of us, my Porsche caught fire during the lecture. So it means that you and I, we made a mistake about the subject matter because I sold something to you that was not available anymore. I thought it was, but I didn't know it caught fire there. That's a shared mistake. In this case, contract is canceled. Parties are restored to their original position. You had paid me, you get your money back, and I will deal with my insurance for the fired Porsche. That's shared mistake. Does it make sense? Yeah. Now, misunderstanding. This is when parties have different understanding about a clause, about an expression, about a word in a contract. They have different understanding. So let's say my company comes into an agreement with your company and goods that you are buying, they will be delivered at the place of business. This expression, place of business, you understood your place of business. And I understood my place of business. So there's a misunderstanding. How do courts solve this misunderstanding? They apply the reasonable person test. What would a reasonable person test understand, interpret from this place of business in this agreement? If court understands my place of business, they will apply this interpretation. If they understand your, they will apply this. What if both interpretations are valid? Then the contract is void. canceled. If both are valid, it means you accepted a different offer that I made. When I made the offer, I meant my place of business. You accepted understanding your place of business. And if both are valid, contract is void because there was no consensus. There was no effective acceptance to that offer. In other words, does it make sense? So that's misunderstanding. Now, one-sided mistake. What is this? When one party makes a mistake. So I go to Apple store and I buy an iPad because I believe the iPad connects with this projector automatically. And then when I get here, it does not connect. Who made a mistake? I did. Will Apple give my money back? In contract law, no. But they will. If I return the iPad in 30 days, they will refund me. This is actually their marketing strategy. They say, up to 30 days, return the goods, we'll give you the money back. It's a marketing strategy. But it's not under contract law. Under contract law, they are not required to. Actually, Home Depot, you can return up to 90 days. You can go there after class, buy an air conditioner, use for the summer, and return it. No questions asked. They do this again as a marketing strategy, not under contract law. Okay, but now let's say you go to a company in which there's no such marketing strategy. How can you avoid to make a one-sided mistake? Let's think about Apple. Let's say Apple does not return a refund. What should I do to avoid one-sided mistake? Read. Review the information before I buy. Okay, I would be avoiding my mistake, but what if I am negligent? I read, and as best as I could understand, I still think it works with this projector, and it does not. But okay, it's one way. Condition? Do you think Apple accepts conditions? I don't think so. They're a big company. But so I don't think they would accept conditions. Could be review the information better. You said something before.
Like, if it doesn't satisfy my needs.
Oh, but this you are coming back to them saying, hey, this does not satisfy my needs. They say, okay, it's your mistake. I have nothing to do with this. Talk to the salesperson. Make questions. Ask the salesperson. If the salesperson says yes, the iPad connects with the projector at BCAT. And if it does not, what issue is this? We just saw it in the beginning. What if the salesperson says it connects, but it's not true? It's false. Misrepresentation. What type of misrepresentation?
Unintentional.
Unintentional. How do we call it intentional? How do we call unintentional acts? Not innocent. Negligent. It's a negligent misrepresentation. It's not intentional because they are not intending. They are not deliberately making the false statement. They are issuing the statement at the best of their knowledge. So it is negligent misrepresentation. So to avoid one-sided mistakes, we should ask, we should make questions. Right? Okay, non est factum, this is a Latin expression that means it's not my act. This is related to a mistake that goes to the nature of the document. Well, this is a defense, but this defense is rarely successful. What this defense is saying is, you enter into the agreement, but you did not intend to enter into that agreement. I enter into this loan, but I did not intend to enter to it. So the way it works is, when you start your banking account, when you go to a bank branch, and you want to open a banking account. So the bank manager, they will print a lot of agreements for you to sign. After, let's say you review, you are diligent, you review all of them, but the manager was so smart that they were able to fit in a loan agreement in all those papers you had to sign. But your intention was only to open a checking account, not to have a loan. But let's say the manager was smart enough to make you sign for a loan. And then next month, they start deducting the interest from your banking account. And then you sue them, or they sue you to collect the money. In your defense, you say, hey, it was not my act, non est factum, because I did not intend to get a loan. I only intended to start a checking account.
Usually.
Not usually, but it could. We could be deceived in a way that, but people would have to be really smart. And this is why I told you that this defense is rarely successful. Because in most cases, we would be signing because we were negligent. We didn't review the papers properly. In very rare situations where we were diligent, but the other party was so smart that they were able to deceive us. Okay, then you would be able to claim this defense. Question for you. Which one?
First one, A.
First, A. Okay, so here in this case, the ship sunk, the coal had been lost. What kind of mistake is this? How do we call this mistake? Shared mistake. Does a shared mistake void a contract? Cancel a contract? Yes, it does. So yes, A is the right answer. B, there was a misunderstanding and the court found the more reasonable interpretation was Sally's. Does it void a contract? No. If Sally's was the more reasonable, then Sally's interpretation will be applied. Price was 800 when the contract was written up. It was incorrectly stated as 900. Will courts void this contract? What will they do? They will correct. It's an obvious error. Sam bought 3 gallons of paint, found he had made a mistake. 2 would have been sufficient. What is this? What type of mistake is this? One-sided mistake. Does one-sided mistake void a contract? No. E. Sam, without speaking to anyone, offered to close because Sam believed it was suitable for growing wheat. After the offer was accepted and the agreement was formed, he learned it was not suitable for wheat. What kind of mistake? One-sided mistake. Does one-sided mistake void a contract? No. So, to answer such a question, you need to remember the types of mistake. Obvious mistakes, errors, courts will correct. Misunderstanding, courts will apply the reasonable person, or they will void if both are valid, which was not the case here. Shared mistake and one-sided mistake. Shared mistake will void a contract. One-sided mistake will not void a contract. So you know the concepts and you apply the concepts here. All right, moving on. Rules of interpretation. Why is this important? Well, courts, they don't like to rewrite a contract. They don't like to give their own definition or own interpretation for a contract. Courts, they will try to stick to the party's real intention as much as possible. And to do so, they will, most cases, apply the reasonable person test. We already know this. They may also use literal or liberal meanings. And with regards to the parallel evidence rule, what does this rule mean? It means that when there's a clear wording, when there's a written clear wording, courts will not accept external evidence. So with a written contract, rarely will they accept witnesses, for example, because they will try to stick to the language, to whatever is written there. And if that language affects consensus, the offer and acceptance, they may void the agreement. But they will not give their own intention to the contract. They will try to stick to the party's original intention. Now, privity of contract. This concept is easy, and it means a contract only binds the parties to it. Okay, so Diego bought coffee before class. If there's an issue with the coffee, can I sue Starbucks? Why not? I'm not part of the contract. So that's what privity of contract says. Only Starbucks and Diego are part of the contract. So they are the only parties that can enforce the contract. That's what it says. Sorry?
If the drink is for you.
If the drink is for me, but I didn't buy it, can I sue under contract? No, I cannot. Not under contract. If the coffee has an issue, can I sue? How can I sue Starbucks? I didn't buy it. Product liability, tort. Okay. So in this case, if I get a coffee as a gift, I cannot sue because of privity of contract. Because a contract only affects the parties to the contract. As easy as it is. However, it's important to remember some exceptions to this. There are some exceptions. The best one I can share with you is the life insurance contract. Let's say Peter buys life insurance. When will coverage be paid? when Peter dies. If privity of contract is applied to a life insurance contract, when Peter dies, no one can sue the life insurance company because Peter died already. So the life insurance is an exception to privity of contract. Why? Because Peter's beneficiaries can sue the insurance company. Or the insurance company can sue the beneficiaries. Does it make sense? So it's an exception to this concept.
What if there's no beneficiary mentioned in the contract?
If there's no beneficiary mentioned in a contract because there's a death, then family law will apply. Family law will say who the beneficiaries will be. Will be their siblings, will be their spouse if they had one, or will be their children or whoever they had appointed in their will, or so the family law will apply.
And it's same as if Peter dies, then his property will be distributed among his children. It's the same process.
Under family law, yes. If there's no will, yes, under family law. Are we good? So it's important to know what privity of contract says, and also important to remember its exception. The best one will be life insurance contract. Okay. I'll discuss this next week or on Wednesday. So now assignment. Well, you will not have assignment in your exam. Okay, so I'm taking out this part from your exam. And because of this, I'll just briefly share with you what assignment is, but you don't need to focus on this for exam. What is an assignment? Assignment is when a benefit is transferred to someone else. So there's a contract. Remember when we studied consideration? What is consideration? The ingredient for a valid contract. What is consideration?
Both parties must get a benefit.
Both parties must get a benefit, mutual benefit. So in a contract, there is benefit for both parties. So let's say I am the client. This is the gardener. I, as a client, I hire the gardener to come to my house. Are we good? The gardener provides the service. I got my benefit. But the payment terms, I will pay the gardener in 30 days. Is it making sense? The gardener needs the money right away. But they don't have the money because I will pay in 30 days only. So the gardener may be able to assign, to transfer their benefit under this contract to a third party that is called assignee. So let's say the gardener, let's say Armin is the gardener. Armin owes Diego $200, and Armin made the garden for $200. So Armin will talk to Diego and say, hey, Diego, I owe you $200. I don't have the money, but I can assign you my benefit. Do you agree? So Armin notifies me, hey, João, your debt is being assigned to a third party. And I say, okay, fine. And then you assign to Diego. You don't get paid anymore, but you already paid your debt. Now, when I pay in 30 days, I'll pay Diego directly. That's what an assignment is. Companies, they do this frequently. We'll see this in chapter 15. Companies, they sell goods, provide services, and they will get paid in 30, 60, 90 days. But they need to advance the money for raw material, for wages, rent, utility bills, etc. So they can assign their books of receivables to banks, to financial institutions. that will then charge interest, but will advance the money to them. Or it could be, let's say, common in the startup world. So there's a company, a startup, they have two business units, and they decide to split. They decide to take one business unit and form a new company. The employees of this business unit that is being split to a new company, they will be transferred to the new company. Legally speaking, the original startup will be assigning those employment agreements to the new company. It's an assignment, a transfer. Okay? Again, this will not be in your exam, but if you want to read more about this, if you have any questions on this, you are most welcome to ask. Okay? I just wanted to give you an overall idea on what an assignment is. There are some things that cannot be assigned. Best example would be support payments. So if a couple gets separated or divorced, one has to pay support payment to the other. The support payment cannot be assigned. Workers' compensation. Anyone who is injured at work files for workers' compensation and is successful, is granted, they cannot assign those benefits. Okay. Yeah. Questions?